Hi, this is Dr. Cora Stack again. I just wanted to continue that. I've been trying to piece the jigsaw together for a long time, so getting closer, the limit to the truth. As I'm working to find the truth, and I'm getting closer, using mathematics and limits and so on. So my story: whistleblowing, constitutional concerns, and why my YouTube likes appear not to be working. Thank you very much for that information from YouTube. My name is Dr. Cora M. Stack. Thank you for being here, especially if you've been watching my recent videos, and fantastic supporting my work and trying to interpret my posts. Today I want to share something very important, a story that connects my academic research, the Irish whistleblowing laws, years of parental alienation, obstacles in the presidential nominational process, severe financial mistreatment and abuse, and more recently, unexpected interference in my online platforms, including YouTube, Facebook, and so on. I'm sharing this in the public interest, and everything I describe is based on my own experience and the effects these had on my life. How I believe it all began, part one. A number of years ago, I carried out academic research on the Protective Disclosures Act 2024, Ireland's whistleblowing law introduced after the Maurice McCabe case. My aim was simple. Well, really, it was a curiosity driven by, what is an act of omission? This was one thing I was curious about because I didn't understand it, not being a lawyer. So it was kind of curiosity driven. But the aim really was to understand how public bodies were implementing the law, to examine whether they were meeting their statutory duties, and to strengthen protections for people who speak up in the public interest. But what I found was extremely worrying. Across different public bodies, different sectors, and different institutions. I mean, they were all on the internet at the time, and none of them are there now. They've all been taken away. So I saw the same thing. What I saw were patterns, and this is what mathematics are. We're trained to examine patterns, and the patterns were very clear. Loads and loads of acts of omission, consistent, widespread, and serious. So it wasn't just one here and there. This was what was clear looking at the patterns, and the reason I'm very good at patterns is because of my training in pure mathematics, which has been undervalued hugely, by the dilution of project mathematics in 2012, so I had done that as well, and I had seen patterns there. So I had, and then actually all of these were reported by the media, on my behalf, the Irish Examiner and the Irish Times, and they allowed me, challenge, what I thought was, very flawed thinking by one of the world's leading professors on, mathematical education, Professor Joe Bowler, and that's up on academia. So, the papers were very good to me up to then, but then everything started to change once I produced this other paper, and data analytics have observed all my research and said the methodology I used was all based on the kind of methodology that I used in those papers which are reported in the Irish Times and the Irish Examiner, and now there's no sign of them. They've just ran for cover. So many organisations simply were not following the law. I mean, I don't know, was this deliberate or not deliberate, but the fact is they were not following the law. I would say, for example, most bodies weren't even aware that they weren't following the law. I would say so. It would only be very senior officials at all, even if, very, very senior people, perhaps the solicitors acting on behalf or people like that. I would say very few public bodies knew they weren't following the law. They weren't, but there were certain people that certainly knew it. The people who had devised these internal disclosure policies, the lawyers are involved and that's why they won't support me. I'm absolutely certain now that's why the legal person won't support me, because they know I know this. This wasn't a few mistakes, it was the pattern. I wrote it all up in a detailed paper called The Implementation of Protective Disclosures Acts and Acts of Omission 2014-2018 and submitted it to the minister responsible and asked that it be examined and protected, and in particular, the recommendations was that it needed to be looked at by the courts and adjudicated upon by the courts. I expected it to be treated as a protective disclosure. Now, it wasn't not treated as a protected disclosure. It was just that was avoided. It didn't say it wasn't protected by that minister. It just said, I note your paper and I note your comments, and I will be, including the inverted commas in the amendment. Isn't that very sanitised? Allegedly. So the response: silence, avoidance, and a sudden new law. The minister acknowledged receiving my research, but it was not recognised as protected. It was not treated as a protective disclosure because it wasn't, for a protective disclosure, it's either investigated or it's sent to the courts at that time. This meant no formal investigation, no independent referral, no judicial oversight, and no accountability. So instead of addressing the issues I raised, the state changed the law. In 2022, the Protective Disclosures Amended Act was introduced. It narrowed protections, it restricted pathways, it created a commissioner who cannot investigate wrongdoing, make findings, order remedies, or refer cases to a court. This effectively retrofitted legality onto past illegality because the failures identified were never examined. Constitutional concerns. Under Banach na hÉireann, certain things are supposed to happen. Article 6, power must come from the people. Article 12, elections and nominations must function freely. Article 28, the executive must stay within constitutional limits. Article 30, the Attorney General must uphold the Constitution. But during the presidential nomination period, the councils, for the first time ever, did not nominate a single candidate. Not one. Statistically, using data analytics and statistics, one of my papers shows this is almost impossible if randomness to occur as a matter of randomness. So this raised even more concerns about whether the system was functioning constitutionally. I cannot say why it happened, but I can describe the effect. It blocked democratic participation for everybody, including myself, and not just me, for everybody. The personal cost, parental alienation. During all of these years, I've suffered years of parental alienation. My children were essentially kidnapped, taken from me emotionally and physically through a long, painful process that the system refused to address. This is something thousands of parents experience, but in my case, it overlapped with everything else happening. My research, legal proceedings, institutional exclusion, and the rewriting of the whistleblowing laws. Does that not suggest that it's all coordinated? I cannot say why these things happen, but the timing formed a deeply distressing pattern. Now, there's a new Supreme Court judgment from Denmark saying that parental alienation or any form of it constitutes severe psychological violence of children. So it's happening at a good time in this regard. So let's say institutions that were contacted supported the violence of my children when I reported it. And I reported to several institutions, and I was repeatedly gaslighted. And I've also done a paper there, and it's been read, called Parental Alienation and Narcissistic Aggression for the, it doesn't refer to anything to do with me, but it was reprehensible that all of this was part, in my opinion, of the retaliation. It was all part of the retaliation. This was all, there must have been something going on behind the scenes that, and leaving me financially in a very desperate situation. All of that, I think, was coordinated as a result of being a whistleblower, following, the research, which was academically motivated. So as an academic, I expected that raising legitimate concerns would be valued. Instead, invitations disappeared, professional relationships changed. I was subjected to severe social isolation. My work was silenced, and I experienced huge reputational consequences. For example, we see in the press recently, huge reputation. This was deeply damaging, both personally and professionally. Digital interference. What viewers have reported here, viewers started telling me that their likes disappeared. They couldn't post likes, this sort of thing. and this was, other things like this. So I can't say that this was wrongdoing, but for viewers to report that they were not able to like my videos is very serious. And I noticed a trend in the past while that this is happening. So I've got to approach YouTube now. So viewers across devices and locations approach the same problem with my YouTube channel. The effect of this is significant. It reduces my reach when I'm finally telling my story. It limits engagement on issues of major public interest, and it makes it harder for me to build a safe community online. Whether it's algorithmic, technical, accidental, or something else, it is happening, and it mirrors the broader pattern of obstacles I'm speaking. Why I'm speaking now? I'm sharing this because people deserve to know how the whistleblowing system really works, how academic research was treated, how parental alienation destroys families and uses as a tool to retaliate against a whistleblower or someone who engages in whistleblowing research, how democratic processes can silence malfunction, and how online spaces become unsafe and unreliable. Everything is described is based on my experience and the effects it had. I'm not accusing any individual or institution of wrongdoing, although I believe several have done me major harm, and this whistleblowing research it was really behind the whole platter of retaliatory behaviour in my life, towards me in my life, and I won't go into the number of institutions who did it, but there obviously was some kind of code in the background. This is a whistleblower, and treat her as such. This an awkward, like even in the court, I was told I had no support. The code was no support, and complainant was used all the time by the by the opposing counsel. So that was whistleblower. So the code to the judge was whistleblower. In other words, give her what she deserves. In other words, what I got, a huge abuse, etc., etc. So what would you call that? So, but the pattern in law, in family life, in academia, in politics, courts, recently and now online, is impossible to ignore. A message to my viewers: if you try to like this video and it doesn't work, or if your comments disappear, or if you can't subscribe, please tell me in the comments or by message. My email address is corastack2@gmail.com. Your feedback is evidence of what is happening, and your support absolutely means everything for you. Thank you very much for listening to my story. I hope and encourage honest discussion, transparency, and genuine reform. Please share this video if you can. It may help others who are experiencing similar issues. And above all, stay strong, stay informed, stay connected. Thank you. And indeed, these raise major constitutional issues which have not been resolved. And the paper is called on nowacademia.eu, which hasn't interfered in any way with academic freedom, and certainly academia.eu are not in the job of retaliating whistleblowers. Quite the opposite. My story. So the paper. Just to tell you what the paper is called, it's just in preparation, but it's a good account of my story, over the years, and the way I was let down and the way I was penalised, and of course I didn't realise it was all penalisation. So there was obviously some agenda, and even for that to end up in a court hearing. And look, if a opposing counsel keeps using codes like complainant rather than applicant, there's an agenda, isn't there? Yeah, there's almost certainly an agenda. That's gaslighting, and that's a code to the judge to and that's why perhaps he did what he did. That could be an element of it. He got a code, and of course I'm brilliant at codes, so I saw the coding from the council, and is that acceptable? Is that acceptable? Isn't it clear that was a whistleblowing, more whistleblowing retaliation, using these codes? And I know, that codes are regularly used in the courts against litigants in person, but like this was this code. Other codes are, for other things I won't go into. I know what they are. You see, they wouldn't realise that I'd spot the codes. So whistleblowing. So the paper on academia.eu is whistleblowing, constitutional duty, and institutional retaliation in Ireland. So, the one thing they can't take away from me is my now world-class research, top 1 to 2% relative to all academics worldwide. As a result of all this retaliation, I've written all the papers and have to do a massive amount of research because I couldn't figure out why I was getting all this retaliation for years and years, that I've ended up putting it all down in a massive amount of papers. So now the whole world is reading the story, and hopefully whistleblowers and democracy will change as a result of my huge penalisation I've had over many years, because I'm advocating for an arbitration first system before going into this archaic justice system where millions are being treated with contempt. And I even got an email last night, a very sad email from a woman with the same story, and she must be one of millions, and looking for my assistance and advice. And so that's just 1 in a million of people who are treated despicably by the courts. But if you're a whistleblower, you can add a huge amount on top of that, and perhaps all illegal whistleblowers, because they have all now helped me to write this paper, and hopefully we will be able to change and tilt democracy in the direction that I'm saying. I can't see other solution, only arbitration first. And you cannot take narcissism out of everything. You can't take the dark trial, but this has the best chance. Arbitration first is the best chance of not taking down these people, but taking down the mindset that unfortunately infects their thinking when they go into these kind of black and white institutions, which are all about defending the institution at all costs to the truth. And it's very sad indeed that the way lay litigants and their truth is manipulated, and they're treated with contempt and hostility by many institutions if they do not come to that institution with a legal team to support them. So it's the same thing, not just in court, in any kind of process or oversight you're involved in. If you don't go with a solicitor, you will be treated with contempt and obstruction and gaslighted from the word go, as I've experienced myself. And now I'm speaking out against all these gaslighters. Let's change it to arbitration first, in the interest of humanity, decency, and democracy, and fairness, and ethics, and things that these people, and morals, these people need to learn a lot more about. And it's very sad indeed that Ireland is not just in democratic crisis or decay, but in serious ethics and moral decay, right from the top to the bottom, but particularly at the top. No ethics, no morals, except very, very few. And we are very lucky, and I'm here because of the very few ethical people and moral people that they haven't got to. Basically, they haven't got to, and I am not paranoid, thankfully. And they tried to, stitch me up with a Medmark report or a medical investigation, at the last minute, so that their story, they've done this numerous times, but they've not succeeded, because the good people, the Act helped me. The Protective Disclosures Act and data analytics, which is placing me now number 1% yesterday in the world in terms of relative to all other academics, and this is the way I've been treated. Well, now I've got all the papers up on academia.ie, and hopefully they are now shaping policy and influencing papers all around the world. I've just looked at my papers, and more countries are looking at my papers, because this is the human experience of how ordinary people without power are treated, and it's time for change.